So first of all, and if you've got the corresponding booklet, you can be following along, and we are on page number 4. So looking at what is an attempt. An attempt is where a person tries to commit an offence but for some reason fails to complete the act, the actus reus. So attempted crimes do not apply to crimes committed by an omission, and attempted crimes only relate to specific intent crimes, so murder, section 18 with intent, theft, robbery, burglary. So the law on attempts, I want you to have a think about which cases you've already come across in causation that relates to attempt. So can you name the case? There's a pictorial clue at the bottom there. That's an old lady, she's quite thirsty, she's fancying a cup of tea. Why was the defendant not guilty of the substantive, so the full offence? And why was the defendant guilty of attempted murder, or why could he be guilty of attempted murder? So have a think back. It's a factual causation case, and the picture at the bottom will help you out. We'll go over the answer in a bit. So looking at the rationale, sort of the moral justification, it's a public policy area. And for your component 3 skills where you're evaluating, this is where this is going to come in. So the defendant's actions are thought to be sufficiently close to the completed substantive offence as to warrant a criminal punishment. And it would be ridiculous if our defendants were allowed to go free simply because they were unsuccessful. So if you try to kill somebody and you don't manage it, you're still guilty of an offence. And the structure that we're going to follow is below. So we're going to look at the definition of attempts, the actus reus, the mens rea, and then discuss impossibility. So what I'd like you to do for people who have got the booklet, I'd like you to have a look at the scenarios on page number 5. And for each of the scenarios, I'd like you to consider whether defendant's actions are merely preparatory, so there's no actus reus, or whether our defendant has taken enough steps to be charged with attempting to commit the substantive or full offence. So, was it merely preparatory, or was it part of attempting to commit the offence? So these are the scenarios, and if you've got the booklet, you'll find them on page 5. So scenario 1, Gemma sees a handbag unattended in the ladies' toilets of her local restaurant, and she hopes that there's money in it. She opens it and looks inside, but there's only some makeup and some sweets, so she closes the bag and puts it back. Scenario 2, Chris puts some poison into Mary's drink, intending to kill her. However, he hasn't put enough in, and Mary survives. And finally, Tom and Darcy are discovered at the back garden of a house with masks on and screwdrivers in their pockets. They admit that they intended to break into the house. So is it merely preparing, or is it attempting to commit? So the law of attempts is defined in an Act of Parliament, which is the Criminal Attempts Act 1981, and the definition can be found in section 1. There are separate actus reus and mens rea elements. So the actus reus is where a person does an act which is more than merely preparatory to the commission of the offence. So it's more than just the preparation. They're embarking on the crime proper. And the mens rea is that they have the intent to commit the offence. So as you can see in the diagram at the bottom, it's further than merely preparing. They're actually embarking upon it, but they haven't managed to be successful in the substantive offence. So the actus reus of an attempt is more than merely preparatory, so more than just preparing. And the act that the defendant commits has to be more than merely preparation for the main crime, but some acts are obviously mere preparation, but other acts are more difficult to categorise. And this is seen in the case below. The defendant jumps onto a greyhound track to try and stop the race, so that the race would be declared void and he could claim the money back that he'd bet, because he realised that his dog was not going to win. His conviction for attempting to steal was quashed because his actions were merely preparatory to committing the offence. He had not embarked on the crime proper, and that is what the case says. I'm aware that it's not the best grammar, but when we are stating the facts of the case and the ratio of the case, that is how you have to describe it. And the Court of Appeal held that more than merely preparatory means that the defendant must have gone beyond purely preparatory acts and embarked on the crime. So what we're going to have a look at now, and if you've got the booklet, we're looking at the bottom of page number 7, is we're going to look at 4 cases, their facts, and categorise whether they're merely preparing or embarking on the crime. So starting with Gerdes, in this case he is hiding in the boys' toilets. But the key part of the case is the test that it gives us. So the question is, has the defendant moved from planning to executing? Has our defendant acted showing that he's trying to commit the offence or just getting ready? And in the case of Gerdes, actually the court held that it was merely preparatory, so he was not liable for the attempted offence. So moving on to Campbell from 1990. In this case, he's standing outside the post office with a gun and a note. And the court held that he was still getting ready and this was merely preparatory, so he is not liable. Moving on to Jones from 1990. So he goes a little further than Campbell. He gets into the car with his victim and points the gun at them, and the victim has to actually throw the gun out of the window to avoid getting shot. And the court held that this was attempted murder because he actually embarked on the crime. So he is liable. And finally we have the case of Boyle. He's found next to a shed with a broken lock. And the court held that he was trying to gain access and this was part of the attempt, because he's actually embarked on the crime there. So he was liable for an attempted offence. So now that you've had a look at the actus reus of attempts, I'd like you to have a look again at the scenarios and see whether this is going to adjust your answers in any way. So let's move on to the mens rea of attempts. If you've got the booklet, we're now on page number 8. So normally the defendant must have the same intention as he would be required for the full offence. And if the prosecution can't prove the intention, then the defendant is not guilty of attempt. In Esom 1971, our defendant picks up a bag in the cinema. He looks through it and then he puts it back. There was no evidence that the defendant had intended to permanently deprive, and therefore he was not guilty of attempted theft. However, in the Attorney General's reference numbers 1 and 2 of 1979, the Court of Appeal decided that if the defendant had a conditional intent, so they intended stealing if there was anything worth stealing, they could be charged with an attempt to steal. So the law of attempts only relates to crimes of specific intent. This means that the defendant must intend to bring about the final result. So you can see on the right hand side our specific intent crimes. So section 18, GBH with intent, murder, theft, robbery and burglary. So you require intention. Recklessness is not in the mens rea. Basic intent crimes, which I'll grade out so that you don't get confused: assault, battery, section 47, section 20 and manslaughter. You can be reckless or in fact lower for all of those offences. So having a look deeper at the mens rea specifically of attempted murder. For attempted murder, the prosecution must prove an intention to kill. To cause grievous bodily harm is not enough for attempted murder, it must be to kill. And this is shown in the case of Wybrow. In this case, our defendant wired up the victim's bath to the mains electricity, and he was convicted of attempted murder. And the court held that you must prove that there was an intent to kill, and attempted GBH was not enough. So there's a question: is recklessness enough to satisfy the mens rea of attempt? And this is discussed in the case of R and Millard and Vernon from 1987. In this case, the defendant pushed many times against a fence on the stand of a football ground. The prosecution said that they were trying to break it, and they were convicted of criminal damage, but the Court of Appeal quashed their convictions. And it was held that recklessness is not enough for the mens rea of attempted criminal damage. So you had to intend. So let's move on to looking at attempting the impossible. If you've got the booklet, we're now on page number 9. So in some situations, some people may intend to commit an offence and may do everything possible in order to commit it, but in fact the offence is impossible. Under the common law, and before 1981, when the Act was passed, the House of Lords held that where a crime was legally or physically impossible to commit, then the defendant could not be guilty of attempting to commit it. However, when the Criminal Offence Act 1981 was passed, it contained a subsection, section 1.2, which was intended to close this loophole and make defendants guilty of an attempt, even though the full offence was not available. So what we're going to see now is the way that the law has developed in this way. So you know I asked you about that particular case at the start? Well, the one I was referring to was R and White from 1910. In this case, our defendant put poison into his mother's drink, but she died of a heart attack and the poison took no effect on her. At the time, she was not guilty because the offence of murder was impossible, and therefore she was not guilty of the attempted murder either. But today, he would be guilty of an attempted murder, despite the fact that the offence was impossible. So the next point in our evolution is section 1.2 of the Criminal Attempts Act 1981, and it states a person may be guilty of attempting to commit an offence even though the facts are such that the commission of the offence is impossible. And this is proven in the case of Anderton and Ryan from 1985. In this case, Mrs. Ryan bought a video recorder very cheaply and she thought it was stolen. Later she admitted this to the police, who were investigating a burglary at her home. Her conviction was quashed because the video recorder was not in fact stolen. And the House of Lords held that even though Mrs. Ryan had gone beyond more than preparatory acts, in fact all of her acts were innocent. The video recorder was not stolen. And on this basis they thought that section 1.2 did not make her guilty. A year later, however, we have the case of Shiv Puri. In this case, the defendant agreed to receive a suitcase which he thought contained prohibited drugs. The suitcase was duly delivered to him, but it actually only contained snuff and harmless vegetable powder. The defendant was convicted of attempting to be knowingly concerned in dealing with prohibited drugs. And this time, unlike the previous case of Anderton and Ryan, the House of Lords said that both section 1.2 and 1.3 state the following. In any case where, apart from this subsection, a person's intention would not be regarded as having amounted to an intent to commit an offence, but if the facts of the case being as he believed them to be, his intention would be so regarded, then for the purpose of subsection 1 shall be regarded as having an intent to commit that offence. So Shiv Puri changes the decision in Anderton and Ryan. So you can be guilty even though it was impossible to commit. So the combined effect of section 1.2 and 1.3 of the Criminal Attempts Act meant that the person could be guilty of an attempt even if the commission of the full offence was impossible. In Shiv Puri, the facts as he believed them to be were that the suitcase contained prohibited drugs. He intended dealing those drugs, so his intention, under section 1.3, is regarded as being an intention to commit that offence. The House of Lords accepted that its decision in Anderton and Ryan had been wrong, and they used the practice statement to overrule the decision. So thinking about the point that we've just made around impossibility, I'd like you to go back, have a look at pages 9 and 10, and I'd like you to have a go at evaluating impossibility. So just that particular point. So what I would like you to do, and if you've got the booklet, you can use the sections on page 1 to guide what you're going to do. For your AO1 knowledge and understanding of the law, I'd like you to state the law surrounding impossibility and explain it with cases, statutes, etc. So you'll need R and White. Section 1-2 of the Criminal Attempts Act, Anderton and Ryan, and then Shivpuri. And then I'd like you to analyse and evaluate those rules. So what's the issue? Well, stating your evaluation point is going to be around, is it fair, is it just, is it reasonable that you can be guilty of attempting an offence that was impossible, that you would never actually be able to do? So what would the arguments that you're going to explain suggesting that it is fair? What would the arguments be that you'd explain to say that it's not fair? And then have a think about, well, why is this? And try, if you can, to include however points. So go through the organiser just to evaluate the really important point around impossibility. So the next thing that we're going to have a look at is application of what we've done so far. So these, for people on Educast, are going to be component 2 skills. And if you've got the accompanying booklet, we're now on page number 11. So on page 11 you've got a set of scenarios, and the first one is about Krista. Krista puts some poison into Donna's drink, intending to kill her. The amount she puts in the drink is insufficient to kill Donna, and Donna survives. So the first thing that you need to do is state your A01 points, which is your knowledge and understanding of the law. So you need to state the actus reus. A person does an act which is more than merely preparatory in the commission of the offence. You can then explain the cases, and the quote, more than merely preparatory, means that the defendant must have gone beyond purely preparatory acts and have embarked on the crime proper. You can then state the mens rea, with the intent to commit the offence, and explain the case of Wybrow. For murder, must have intended to kill. For attempted murder, intent to do GBH is not sufficient. So that's your A01, that's your knowledge and understanding of the law. And remember that that's your foundations, that's your building blocks. We'll now move on to the A02, which is the application to the scenario. So still thinking about Donna and Krista, applying the actus reus. So Krista has obtained the poison and then puts the poison into Donna's drink. It would appear that Donna has also drunk some of it, and this indicates that Krista has gone beyond a merely preparatory act and into the actual commission of the offence. And the mens rea, well, we're told in the scenario that she intends to kill her, and therefore she has the mens rea, the intention to kill. She would not have had sufficient mens rea for attempted murder if she'd simply intended to cause grievous bodily harm, and therefore Krista should be liable for attempted murder. If you've got the paper booklet, you can now move on and do the A01 and A02 for Gregor and Hans, and also Isan and Johnny. So now that you've looked at some shorter scenarios, you're in a good position to look at a long exam-based scenario. So this is a real exam scenario from a few years ago. And as always, we start by looking at the question. So discuss the criminal liability of Tanya So starting with the AO1, you need to state and explain the law on murder. So you need to define and apply murder, an unlawful killing of a human being with intention to kill or inflict GBH, or foresight of death GBH as a virtual certainty. So you then need to define and explain causation using the but-for test, Roberts, causation in law, operative and substantial, so something like Cheshire Smith, for example. You then need to define and explain the mens rea of murder, so direct intent for death or GBH, being the defendant's aim or purpose, oblique intent, foresight of consequences. You then need to state and explain the law surrounding attempts, so define and explain attempts using the Criminal Attempts Act 1981, Actus reus under section 1.1, doing an act which is more than merely preparatory, and you also need to state and explain the defences of intoxication and mistake. So for intoxication, you need to define and explain the defence. So it means that the defendant doesn't have the ability to form the mens rea. If a crime requires specific intent, voluntary intoxication acts as a partial defence. If the crime is one of basic intent, voluntary intoxication is usually no defence, and if voluntary intoxication due to Dutch courage, then there is no defence. You also need to define and explain the defence of mistake. For some of you, this is going to be something that we haven't studied yet, but you can come back to this and this will all make perfect sense. But for completeness, we will include it here. So, can be a defence if it's an honest mistake, as in Gladstone Williams or Beckford, and it will not be a defence if induced by intoxication, as in O'Grady. And you can use any other cases, any other relevant points. So now we have to do our AO2 skills of And moving on to the issue with the newspaper through the letterbox and the death of Arthur, there's a possibility of murder as there is unlawful killing of a human being. The mens rea is more problematic as Tanya has the intention to frighten, but it may well be oblique intent. Possible defence of intoxication as she's drunk 3 glasses of wine. Possible fallback charge of manslaughter to which Tanya will have no defence. If drinking is seen as Dutch courage, then Tanya will have no defence, and you have to reach a reasonable conclusion based on those facts. And the final skill that we have to develop is our AO3 So let's have a look a little deeper at more than merely preparatory. So we have 3 cases that we've looked at that show the courts are not always prepared to take a broad approach when deciding what more than merely preparatory means. However, it can be argued that the more than merely preparatory test is an improvement on the law as it stood prior to the passing of the Criminal Attempts Act. The old law used a variety of different tests, so it was not always easy to predict which test would be used and the outcome. So now let's have a think about protecting of the public. In considering this, it's also necessary to ask why attempting an offence should make someone criminally liable. The main justification that it can prevent the full offence from being committed. It would be ridiculous if the police had to wait until the defendant fired the bullet and killed the victim instead of being able to arrest them for attempted murder. So given that prevention of crime and protection of vulnerable victims are important, the decision in Girders and Campbell in particular are quite hard to reconcile with this. Moving along, should intention alone make the defendant guilty? The opposite point of view is that the defendant should not be criminally liable for his intentions. He must actually do something towards the commission of the full offence. And this raises the question of whether Parliament should have made defendants liable where the facts are such that the commission of the full offence was impossible. Should Shiv Puri, being guilty So thinking about the level of mens rea, another issue in relation to attempt is that a higher level of mens rea is required for some attempt of some offences than required for the full offence. For example, in the offence of murder, mens rea can be proved by showing that the defendant intended to kill or that he intended to cause really serious harm. However, for attempted murder, it's necessary to prove that the defendant intended to kill. Intention to cause really serious harm is not sufficient for the mens rea of attempted murder. This makes it appear that the law is more favourable to those charged with the full offence. However, a defendant who intended to cause really serious bodily harm but did not commit the full offence can be charged with the offence of attempting to commit grievous bodily harm, contrary to Section 18 of the Offences Against the Person Act 1861, so does not entirely escape liability. And the final evaluative point to think about is recklessness. There's also a discrepancy in the law that recklessness is not usually sufficient for the mens rea of an attempt, even though it's sufficient for the full offence. So, was the acquittal in the case of Millard and Vernon justified? Should the fact that they were reckless in repeatedly pushing against the fence have made them liable for an attempted criminal damage? Or is it more justified that the prosecution had to prove that they intended to damage the fence? If they had just been liable for attempt through recklessness, this would have meant that they were being found guilty even though they had not formed any mens rea. After all, it is a key principle of criminal law that a person should not be guilty unless they have a guilty mind. So let's have a look now at the Law Commission Report 2009, Conspiracy on Attempts. So this included a draft bill which was published on the 10th of December 2009, and the report follows a consultation paper which was published on the 10th of October 2007. And this report made a range of recommendations. It includes clarification on the existing law. It also included making explicit the requirement of proof of intention that the conduct element and, where relevant, the consequence element should take place. provided that the substantial offence provides for subjective fault element, so subjective recklessness, in relation to the circumstances element, that the prosecution must show that the alleged conspirator had the same fault element as to the circumstances, and provide that the exemption from liability of a defendant of conspiracy should be retained as long as the conspiracy is to commit an offence that exists wholly or partly to protect a particular category of persons. The defendant falls within the protected category. So the report also recommends, as to the way in which conspiracy should be charged, and for the retention and the current exemption from liability for a person who conspires exclusively with a child under the age of criminal responsibility. And the report also sets out recommendations to rectify certain aspects of the Criminal Attempts Act 1981 for the offence of attempt. So this is the key thing, this is the key element of this report that you would need to put in your A03 evaluation of attempts. So the aim of these recommendations to rectify was to allow the courts to convict a person of attempted murder if he or she deliberately failed to discharge a legal duty to another person with the intention of killing that person. To ensure that a person can be convicted of an attempt for his or her intention to commit an offence that was contingent on a condition, and to clarify the fault element, so the mens rea element, which needs to be proved for a person to be guilty of attempt. So as part of your conclusion, and having listed at least 4 detailed criticisms, problems with the law of attempts, you would And so if you've got the booklet, or if you don't, you need to explain in your own words what the report said, specifically about the attempts. And so finally, you should be in a position to answer this question. In what ways did the Criminal Attempts Act 1981 improve on the common law? Is further reform now required? If you've got the booklet, you have the space to do this on page number 16. So as always with these component 3 evaluations, you start off with your A01 because this is worth 10 marks. So knowledge and understanding of the law, state the law, explain it with cases, statutes, reports, etc. And then A03, analyse and evaluate legal rules and principles by referring back to your A01. So state the point, explain it with some evidence cases. Why is this relevant, linking back to that question? Try to include however points if you can, and then suggest whether reform is needed or appropriate. So that concludes the law on attempts. Please make sure if you have the booklet you have filled it in appropriately, because if you have the booklet it will be checked. Thank you very much.